Surviving the Survivor, we bring you the best guests in all of true crime. Don't forget to subscribe and smash that like button. Here's your host, Emmy Award-winning broadcaster, Joel Waldman.
What's up, STS Nation? Welcome to Surviving Survivor, the show that brings you the very best guests in all of true crime on trending criminal cases. And this is a case that's been trending for the better part of 11 years. We're going to go straight out to Judge Everett. This started a few minutes early. We're going to bring this up. There he is, Judge Everett.
Just be able to sit down, and then y'all get started talking to them. If they cannot hear you, or you cannot hear them, let me Miss Carson.
Hopefully that audio gets better. This is a Zoom call.
This is Adelson. Can you hear me?
Yes, I can.
All right. Let's do a mic check so you can hear everything happening in the room. Zelman.
Joshua Zelman on behalf of Mrs. Adelson.
Jackie Fulford on behalf of Mrs. Adelson.
Sir Catherine Dugan on behalf of the state.
All right. For everyone who has joined the Zoom this afternoon, there is not to be any recording of the Zoom. The pool camera is the only designated camera that is going to be recording the proceedings today. We're here this afternoon on the defendant's expedited motion to continue the trial. The state has filed a response to this as well, and the defendant has filed a reply. In addition, the defendant has also filed a motion to compel. Mr. Zelman, you may argue your motion.
Your Honor, before we do that, I believe that email from your office also indicated that you wanted to address the scope of the ceiling. That might be.
We'll get to that at the end, but unless you believe we need to do it right now.
Given the nature of materials and the basis for the, in part, the basis for continuance as well as the motion to compel, we would request that it be addressed at the beginning of the hearing.
Very well. Concerning the scope of the ceiling, when this matter was first presented to me, when we had the phone conference on April 8th, as it related to matters pertaining to the warrants and any affidavits and any support for those as to the investigation that recently concluded, I am in agreement with you, those matters would be confidential. However, every filing that may even reference those materials, sealing those filings starts to become a question of whether things are exceeding the scope of confidentiality that's allowed by the rule of general administration. Mr. Zelman, why should all of these matters remain sealed without redaction or other means that could be made to otherwise deal with the portions that are confidential?
Well, Judge, Jackie Fulford on behalf of Mrs. Adelson, our position is that the information that's contained in the items that Your Honor is referring to would need to be referred to also in the arguing of these motions. And we're here in open court, and I'm not sure how we protect the sealing of those documents when we're going to have to argue the very materials that serve the basis of why we're here asking for a continuance and a motion to compel.
Is anyone actually getting into the warrants or the affidavits themselves with what you plan to argue?
Yes, Judge, and the materials from the investigation.
You have those to actually bring up as a part of your argument today?
Yes, Judge.
Not generally, not just referencing them, but the actual materials from the warrants and the affidavits.
Well, there need to be statements put on the record on behalf of Mrs. Adelson regarding what was claimed to have happened in the investigation that has since proven to be false, that has not been retracted by the state. And in making those arguments is part of the basis for why we need a continuance and why we're asking for the relief in the motion to compel, as well as additional depositions. And
to that end, Ms. Dugan, is the state planning to file any superseding indictment or any additional charges based on the investigation that is now concluded, or at least is alleged to have concluded?
No, sir, not to my knowledge.
With that being said, if the defense is seeking to file any motions related to these matters, they are not related to pending counts. However, you can pursue them as you believe them to be appropriate. As to the warrants and the applications, does the state have a position as to whether they should remain sealed or any documents referencing them should remain sealed without redaction?
No, sir. We would defer to the court And some of the discovery the defense has moved to compel is sealed, or a lot of it is. And I actually brought a motion to unseal the documents and recordings related to that today so that those can be provided to the defense, but maybe for the limited purpose of discovery, but whatever the court prefers, we don't have a position.
Mr. Zelman was full for any additional argument.
No, Your Honor.
With there not being additional charges to be filed by the state concerning these matters, the court is going to unseal at this point the filings that have been previously filed under seal as it relates to the motion for continuance, the state's response, and also the reply as well. Any other matters that need to be reviewed by the court or to be unsealed from here, the parties need to appropriately raise.
We have just a moment, please.
Go ahead.
Your Honor, if I could just ask for clarification, are you indicating that you're unsealing the pleadings, but not the actual underlying applications, affidavits, and warrants, or you're unsealing
Not the
everything?
warrants, not the affidavits, not the applications, but pleadings that reference those matters, yes.
Just one moment, please.
Your Honor, would you give the defense an opportunity to propose redactions to the pleadings, given that they relate directly to those underlying materials, and in fact, in some points, quote them?
Absolutely.
Thank you.
Again, as to redacting those matters that would remain sealed, that is certainly appropriate under the rule of general administration. As to each doc or each docket entry or each document itself remaining sealed, just by incorporating by reference those matters, I believe that's getting a little bit further than what the rule requires.
Yes, sir.
Mr. Zelman, you may make your argument at this point.
Your Honor, the expedited motion to continue that was filed on April 21st. I try to make my arguments as clear as possible in the written pleadings. What has come out about 3 weeks ago is the state conducted this additional investigation into allegations. As part of that, they obtained additional records. We also learned approximately 2 weeks ago during Investigator Newland's deposition that the state had not given us materials that had been given to prior counsel. So we've been asked to trust without the ability to verify. And in fact, months ago, I asked the state for a list of the materials, everything that they had, everything that Corbett had, so that we knew if we had received everything. And they did not provide that to us. So now we have received it from the materials we received over the last few weeks. It appears to be over 100,000 emails. We have purchased 3 pieces of software in addition to the software that we used previously, trying to.
Is this to sort through or sift the emails?
Some of it's to open it, some of it's to sort through. Yes, Your Honor.
Go ahead.
None of them are very effective at doing that. So we've actually engaged a e-discovery platform to assist us, but that hasn't even been set up yet. That was a decision that we made last night after trying that additional piece of software yesterday. In addition to that, we have new cell write extractions from Mrs. Adelson's phone. I understand in the state's response to the motion to continue that they don't intend to use any of that, but that doesn't mean that there's not something in there that we want to use.
And I did want clarification on that point. As to the discovery provided to prior counsel, Ms. Dugan, the response of the state is that on October 31st and November 8th, the raw data from the defendant's phone and email accounts were provided. Is that correct? Is that what your response is getting to?
Is this concerning, can you tell me what-
Just the raw data from the defendant's phone and email accounts.
Yes, sir. Those have all been previously provided. I thought he was talking about the 100.
We're going to get to the filter team documents. The best way to do this is to take it into bite-sized pieces so it's clear what is being argued, what is not.
Yes, sir. So it's my understanding that all of Mrs. Adelson's phone records were previously provided in November 2024. There were certain phone records, I believe it was 7 pages of phone records that were actually, this is going to be paragraph 7 of the defense's reply to the response. These are phone records that Donna Adelson's prior defense counsel had an issue with us not having. So these were subpoenaed. TPD received them in October of 2024. The state attorney's office didn't know TPD had received them. TPD didn't know that we didn't have them. And so that's why they weren't disclosed. But ultimately, they have now been sent to the defense.
Another term you start to hear sort of thrown around a little bit more by
Ultimately, though,
Go ahead.
yes, sir. I'm told it's 7 pages of records. So those were the 7 pages that they did not have that weren't disclosed to them last fall. That's my understanding. And we would object to a continuance based on those pages.
All right, as to any additional raw data from either your client's phone or email accounts, are these not in your possession at this point?
We have them, but that's the materials that we've been struggling to try to get through.
And again, this was disclosed back in October and November, or when did you receive it?
We did not receive those materials, Your Honor, until it was after, if Your Honor recalls, during the expedited hearing that we had a couple of weeks ago by telephone with the state and defense on the phone. Those were the records that we were addressing then, and I believe that we got those April 10th, 2025. And that's, the state actually acknowledges that in their response.
All right, Mr. Zelman, you're not going to make your argument for you, but ultimately you believe you need to review these to be prepared for trial. So
Yes, and those aren't the only issues that have been arisen over the last few weeks. The motion details the additional issues. But needless to say, we have spent the last 3 weeks trying to collect this material, some of which we still don't have.
you're referring to the recent investigation.
Yes.
Go ahead.
And even if the state isn't going to use the information, we still need to know the extent to which they violated, they intercepted and monitored attorney-client communications and communications that are protected by the fiduciary client privilege. We don't have all of that information yet, and they have not responded. As indicated in my reply yesterday, the state hasn't responded to those emails requesting that information.
Ms. Dugan,
Yes, sir.
concerning the aspect of the recent investigation, which materials are yet to be provided and why?
Yes, sir. May I also address the 100,000 emails?
Go ahead.
So those 100,000 emails are redacted privileged communications that the defense recently received that occurred between the Adelsons and prior counsel. This communication was redacted by a taint team. It's never been seen by the prosecution.
The filter team document.
Yes, sir. Thank you, filter team. It's never been seen by the prosecution. It's obviously privileged. We obviously do not intend to use it in our case, having never seen it. And I also can't imagine a scenario where the defense would be using it in their case. I would feel like all of that information would be hearsay and self-serving hearsay. So the state is objecting to a continuance based on they're needing to review all of the privileged communications with prior counsel.
When were the filter team documents provided?
They were provided on April 10th during, one second, I want to double check. During Jason Newland's deposition by this defense team. Somehow some question was asked where he referred to the filter team that the court referenced. And this defense team was not aware that the filter team had gone through all of those emails and kept all of the privileged emails from the prosecution team and provided them to former defense counsel. So those were then provided to this defense team.
Very well.
And Your Honor, I could address that very briefly. Judge, advice of counsel is something that would be relevant. It goes to Mrs. Adelson's state of mind. And if there are any emails in the records that we received 2 weeks ago that would rise to that level, then it would absolutely be relevant and admissible if it goes to her state of mind concerning, for example, her leaving the country.
Well, I was going to say, particularly as to that issue, what advice she received and what she relied upon in making that decision. That would be up to the finder of fact to determine, was she relying on the advice of counsel or was she in fact trying to flee? The emails, though, and your client does not have to testify, but ultimately this would go to how would the emails themselves be admitted versus her giving her recollection or recitation of those.
That still doesn't mean that the emails themselves would not be admissible.
Let's put a pin in that. That'll
Yes,
be subject to any argument in the future
Yes,
as to how the emails themselves could be admissible. But if your client chooses to take the stand during the trial and waives any prior privilege with Mr. Rashbaum or anyone else concerning advice that she received on leaving the country, that is certainly up to her.
Yes, sir.
On the back to the recent investigation discovery, Ms. Dugan, the items that have not been provided, I believe some of these pertain to the parameters in the Title III that were supposed to operate as safeguards. Is there a reason this has not been provided to the defense?
So looking at the reply and the motion to compel, all of the things that they're requesting here as far as the minimization instructions, all the logs, all of those things, I feel once the order to unseal has been signed, those can't all be disclosed. The only thing that I saw that would be additional that they are asking for is surveillance video, which is surveillance video from the jail, which I've been told has already been disclosed to the defense. They also asked for the financial records that are mentioned in the application. I was told that we subpoenaed Harvey Adelson's Zelle account. I found that those Zelle records and had it sent to the defense this afternoon. So once those items are unsealed and they can be disclosed to the defense, that should be all of the discovery that pertains to the wire.
Please provide the order. Has the defense been able to take a look at it?
No, sir. Let me show them what I have, and if I need to change anything, I'll happy to.
Real quick, Zelle is a system used by banks in order to send and transfer money. A la Venmo, similar. The basic headline here is the defense says they got over 100,000 emails. We had heard 80 to 85,000. $15,000 in addition to that. They want a continuance. State making the case why it should not happen.
You may.
Your Honor, there was one issue that Ms. Dugan and I addressed concerning the motion and order, and it has to do with the discrepancy with Investigator Newland's memorandum, 17-page memorandum. The memorandum that he authored indicated that the wire went down February 24th. Ms. Dugan is telling me that the wire actually went down on February 21st. So if we can just make sure that that's accurate.
Yes, this is one of the paragraphs in the defense's reply. That was just a mistake on the memo. The wire came down on the 21st. I believe the significance of the 24th was that was when the order was signed. And I think Mr. Newland's memo said the 24th, but it is the 21st, which is reflected in the order the court's looking at now.
All right. Court will sign the order at this time. I believe that deals with your motion to compel, Mr. Zelman.
May I address one more thing about the issue we were just talking about? There is obviously this new discovery from this lead that the state was alerted to last fall. We conducted this investigation and followed that investigation to its conclusion. That obviously has resulted in some new discovery in these wire calls. But I did want to let the court know, though there are a large number of calls that the defense, of course, wants to review, there are only, I was told, about 30-something calls deemed pertinent by law enforcement, and the state likely plans to only use maybe one or two at trial, and believes that the 2 months the defense had from the time it was discovered to the time of trial in June should be sufficient to prepare for that portion of the trial.
Do any of the calls that you intend to use from this recent investigation go to privileged matters or encapsulate calls with counsel?
Thank you. I wanted to address that. There are no calls that were recorded between the defendant, Donna Adelson, and attorneys in this case. I specifically asked the investigator about that before the hearing.
Zelman, you may continue with your argument.
Yes, Your Honor. The state has also not responded to our request to let us know if they've also been monitoring our attorney-client conferences at the Leon County Detention Center.
That's a no.
And although the state believes that we're going to have enough time, I calculated this. There are over 32 hours of calls that were captured on that wire. And given the amount of materials that we have just been handed, we have not had an opportunity to review even 2 hours of those calls up to this point. Your Honor, just because the state believes that there's going to be enough time for us to prepare, and it's not 2 months, it's more like 6 weeks. There's not enough time for us to analyze this new information, synthesize it, prepare appropriate motions. We've spent the last 3 weeks dealing with this as opposed to finalizing the motions in limine.
That is an important point you bring up. Essentially, between what has been recently investigated and what the charges have been of murder, solicitation, and conspiracy from the time your client is charged, there are essentially two different pots, if you will. For the motions that the deadline was today as to the murder, solicitation, and also the last count as well, are those motions completed?
No, Your Honor, we've only had an opportunity to finish 2 additional motions that have not yet been filed. And I have not had an opportunity because we had to adjourn Investigator Newland's deposition to finish the Frank's motion.
Right. So you are in fact asking for an extension on the deadline to file your motions.
We're going to need one in addition to the continuance. Yes, Your Honor.
Ms. Dugan?
If the court wants to give an extended motion deadline, we don't have any objection to that. We do object to a continuance of the trial and we remain ready for trial.
What is the defense? Well, before I come back to you, Mr. Zelman, what is the prejudice that the state would suffer if the trial is continued, Ms. Dugan?
We would not.
Beyond just a mere objection.
We would not suffer prejudice, Judge. We're just ready for trial if it goes as continued.
Mr. Zelman, what would you be proposing as a date? And you also have to keep in mind, there's only so many points in the year a trial that could take either 3 weeks or more can be scheduled. And I assume you've discussed with your client if your relief is granted.
We have.
What that means.
We have, Your Honor. And frankly, without getting through all of this new material, it's hard for us to pinpoint exactly when. I mean, we're not going to sit around on our hands and do nothing. We have been diligently preparing. We're going to continue to diligently prepare. Likely 2 to 3 months would be, I think, realistic. But again, until we get through all these new materials, it's going to be hard for me to say.
Right. Concerning the motion deadline, which was supposed to be today, I will set a new deadline, particularly as to the counts that have already been a part of the indictment and have been charged all along. The murder, the conspiracy, the solicitation, the deadline filing any motions relating to the existing charges will be May 16th. The motion hearing that was scheduled to take place on that day, we will reschedule at a later point. Court is going to reserve ruling as to whether the motion for continuance will be granted. The parties are to confer about any redactions that you believe would be appropriate to the filings for the expedited motion for continuance, the state's response, and also the defendant's reply, and the motion to compel discovery. Any other matters that we need to address before we finish up for today?
Your Honor, with respect to the motion to compel, the state has also not provided the disclosure that's required by Rule 3.2201BM concerning the jailhouse informants. We've also moved to compel that material as well.
Give me a moment. I'm just going to bring up the rule. So this is 1M, which subsection?
1BM.
1BM. Student in response.
I'm sorry, Judge, I'm having trouble getting on the Wi-Fi. Is there?
This is in the discovery rule under the prosecutor's discovery obligation. And I will quote from it.
Thank you.
Whether the state has any material or information that's been provided by an informant witness, including the substance of any statement allegedly made by the defendant about which the informant witness may testify, a summary of the criminal history record of the informant witness, the time and place under which the defendant's alleged statement was made, whether the informant witness has received or expects to receive anything in exchange for his or her testimony, the informant witness's prior history of cooperation in return for any benefit is known to the prosecutor.
Yes, sir. Thank you for that. I'm familiar with that role, but just didn't know all of the different things we needed to show there. Some of that has already been provided through the recordings. However, as far as her history, any benefit, all of those things, we'll disclose that to the defense as soon as possible.
Please disclose it by Friday of this week by 5 p.m.
Yes, sir. And may I also ask about today is the discovery deadline, which the state is prepared to obviously comply with. As far as though now the order on the continuance maybe being later in the week, would it be okay if we had a discovery deadline of 24 hours from the order, or would you rather keep it for today?
Concerning, again, the charges that have always been in place, the murder, the solicitation, and the conspiracy, is either party seeking more discovery on those charges that has not already been addressed up to this point.
Judge, the issue with complying with today's deadline is we have spent the last 3 weeks dealing with these other issues. We have
Not the motions. I'm saying are seeking additional discovery on the indictment charges.
We are not going to be able to meet the deadline to provide the state with our discovery because we have been focused for the last 3 weeks on other issues.
Student.
The state can comply with the discovery today. I just didn't know if given the possibility of the case being continued later this week, if it were possible to have 24 more hours after that order came out. But if it needs to be today, the state can comply with that. And the state would hope that the defense can comply too, or get discovery as quickly as possible to us.
Once a ruling has been made on the continuance of the trial, the court will also address any deadline for discovery as well. For now, please operate as if the deadline remains in place. Wait for the order.
And Judge, I just want to make it very clear, there's no way we're going to be able to get it done, even if we were to work straight through till midnight.
Again, Mr. Zelman, as to that, what can be filed, please do.
Yes, sir.
I will let you know once we have a motion, or excuse me, once the order is on the motion to continue, whether the deadline for everything else related to today's deadline applies as well.
Yes, sir.
We are in recess. For everyone, that is the end of the hearing today.
That is a 32-minute hearing. Judge Stephen Everett in Leon County, where Tallahassee, Florida, is presiding over Donna Adelson versus the state of Florida. This was a hearing about a potential continuance. A lot to unpack here. Tons to go over. The headline here, Joe Patuto and Tim Jansen, by the way, should be joining momentarily, and then we'll try to get additional people on to get a varied take on what's happening. But to me, the headline here, Tim had been telling us 85,000 emails. That number is higher than we thought. It's at 100,000 emails. But I think even more importantly, we learned today that the state got some sort of tip this past fall and basically followed an investigation through to the end per Sarah Dugan. And as part of that investigation, there's something like 32 hours worth of quote unquote wire calls. We remember those early on between, Charlie and Donna and other people going back and forth where the FBI had a wire. Joe Patuto, it's going from interesting to intriguing here. It's getting more and more layered. Let's just start to break it down piece by piece. Let's start with, the bottom line here, the judge did not reserve on whether or not, did not rule. He's reserving ruling on whether this trial will be continued. But the defendant has every right to a fair trial. Is this trial going to get continued?
My guess would be no, yes. What the defense said was they were unable to comply, and they're certainly won't be able to comply with everything that was supposed to be submitted on the discovery deadline today, because rather than work on their motions, they had 7 motions that they had filed, rather than work on that or even work to prepare for the trial, they've been, I think Zelman said, uh, consumed with the new discovery that they've had to read. The state said for a good part of it, they don't think there's anything in there. They said at one point that law enforcement on the wires that started in, I guess it was October, that law enforcement said there might be 30 that were pertinent. And she said, well, there are only 1 or 2 we would use. And Zelman said, yeah, but we don't know that there isn't something in there that we want to use. We don't know whether there's anything privileged. Sarah said there is nothing privileged. The wire doesn't include any conversation between Donna and her lawyers. They also asked about whether any of the conversations at the jail were recorded, and she said she had checked. The answer is no. So at least part of what's underlying all this is the extent to which there might be privileged communications. And if I can go backwards on this, they talked about a review of, I think it came up during Newland's deposition that the defense was doing, a review of a number of documents. I think a lot of them might have been wires. The state has never seen them. They used, I think what they call it is a filter lawyer. What they do is if there's a conversation that might contain privileged information, in other words, it's a conversation by a defendant with her lawyer, the state does not look at that information or listen to those conversations until someone else has reviewed them and concluded that there's nothing privileged on them. And what they talked about was they had, I think it was a filter team that different jurisdictions call them differently. I think, yeah, they called it a filter team that went through all of that and decided and held back anything that might be privileged. So the state has never seen them. But what Donna's lawyers say is they didn't know that those records existed, that the filter team had them until I think it was when Newland testified. And they want to see those to see if there's anything in there that they might want to use in one way or another.
Yeah, Harold, anything but dull here. There are more potential charges discussion. He did ask if there was a superseding indictment. My understanding from Sarah Dugan and Georgia Kappelman is still very much part of this case. She just has a big caseload, and so they switch off. COE, what's happening?
Hey, just wanted to check in. While you guys were watching the hearing, I was on Zoom watching Donna watch the hearing, and I just wanted to give you guys a quick update. So we are not able to share that video. That's the court's request, but I did watch her the entire time, and she looks pretty much the same that she did last time. The only difference is I did notice her eyelids were very heavy. She was very subdued. She seemed very relaxed, and she had absolutely no reaction. There were maybe a handful of times that she looked off to the side away from the camera, but for the most part, she was very quiet, never reacted. She was wearing a purple jumpsuit with a white t-shirt underneath, and she had her hair back in a ponytail, and it was a deep side part. So she looked similar to how she looked a few hearings ago, but just very, very quiet, subdued, watching and listening, but very, very calm.
COE, is the implication, is the intimation that perhaps she's medicated for this hearing? What do you think?
I'm not implying anything. I'm just stating the facts.
By the way, how did you describe that part? You would never get that reporting from me. So this is excellent reporting.
There you go.
Yeah, it was a serious part. How did you describe that, COE? Oh, she's off. How did you describe that part?
A deep side part.
Deep side part. I want to remember that. I'm going to use that. The
You
COE
only
watching.
use it if it's relevant. I mean, do you know what a
Yeah.
D-star pipe looks like? I mean, you just can't throw it
I mean,
in.
that's a good point. It's a good point. But the COE watching Donna is like me taking a picture of the COE while she's taking a selfie, which
So,
I've done before. She gets mad.
so
But
if I can try to identify, as I understood, because that went pretty quickly, and I
yeah,
haven't seen a lot of, some of this is under protective order, and I haven't read some of the documents that they're talking about, but it sounds as though the 100,000 documents are all those that occurred when Donna had Roshbaum as her lawyer. And those are the ones that the filter team went through and that the state has never seen and the defense has not seen that they want. There was also an issue with regard to financial records of Harvey that were on Zelle. There are 7 pages of records that the defense says they've been unable to open, even though they've had them a couple of weeks. They said they tried a couple of different programs, and now they're looking at some other program. I wrote it down here. I can find it in order to try to get those open. And then there is the information that resulted from the new investigation that was done last October. Sounded like there were 32 hours there of wiretaps, and those are the ones that law enforcement said there might be 30 or so that are relevant. The prosecutor, Sarah, said they've reviewed them and they think they would only use 1 or 2. So there are at least four different buckets of things with regard to the challenges. And I don't even have all of them. He had a couple of others in there. And what the judge said was any discovery that was supposed to be submitted today based on the original indictments. Now, that's not the investigation that happened in October. That would be new. But what they knew when he set those dates and said everything needs to be in today should be in today. And Sarah said they could do it, but they'd prefer to wait until he decides whether there's going to be continuance and get another 24 hours. Zelman said they're not prepared to be able to do it because in the last 2 weeks, they've been consumed with all the new information. So they weren't able to get their act together to get the stuff that was supposed to be provided today in terms of discovery over to the state. And Judge Everett said, okay, but get in today what you can. So we don't know how much of the discovery that the defense owes to the state is going to come in today. They still have to do that. So that's still open. They've got what he said was 7 pages of records that they have been unable to open yet, so they don't know what's in them. And the information on the 32 hours of wiretaps that they have only listened to some of them, that they said they also have not been able to review, which is why I said I think the likelihood of a continuance is pretty high.
There you go. And we're gonna keep breaking this down. Like I said, Tim Jansen is supposed to join. He may have been in court. He was supposed to go, and they got tied up. And then Steve Cohen's working behind the scenes to bring in a few more people just to get some different perspective on all this. But again, the headline is that there's over 100,000 emails. It doesn't sound like they're all or even close to all being pertinent, but the defense using it to say, hold on a minute, we got to go through these and make sure that there's nothing in here that we don't want, even if the state doesn't want them. Right. And then I think the bigger thing here, the bigger headline that's that kind of got snuck in today was the fact that there's this investigation. Let me just ask you about that for a second, Joe, and then I need to go back over a lot of what you just went over. But as it pertains to this investigation, they said it was from, I think it was Sarah Dugan said it was this past fall. The timing of that is sort of interesting because it's a while at that point since Donna's devices were seized. It's not right after the arrest. Any thoughts? I mean, on what could have triggered that investigation?
Yeah, I don't know. The only thing that I can guess at all, but it's a pure guess, so the chances of it being correct, you can take it for what it's worth. But the only new information that I can think of that surfaced probably last fall was Wendy's friend who reached out to the Markels, and then the Markels sent the information over to the state, and she said she had something she wanted to share. So that's the only, and it's a guess only because that's the only piece of information that I know of that has come more recently than anything else that's been in the case.
Yeah, that's
So could be wrong, but you know.
yeah, that by the way is Sarah Youssef, and that
Right.
happened right around that time period. So that's a great call. She apparently, I don't know if falling out is the right way to describe it, but she's a one-time friend of Wendi Adelson that reached out from what we understand to the government here, and that might have triggered an investigation. And then Joe, you'll also recall they were talking to Scott Radius, who Harvey was talking to, who's a friend of Charlie's and owned some property in Vietnam and worked over as a former law enforcement officer. Is it possible that they were, looking at stuff he was telling them as well? I mean, that's
Don't know,
possible.
and I can't recall when Harvey talked to him. They were arguing over the property that Charlie had put some money down on, but they did it under the table because Charlie was not a resident of Vietnam and couldn't formally own property, as I recall. So they were putting it all in Scott's girlfriend's name. But I don't remember when those conversations happened and when Harvey started to push to get the money back.
Yeah, and Harvey, yeah,
Somebody might remember. Yeah,
he wanted the refund.
right.
Point
And I
to
will add something else, Joel. They talked about a Frank's hearing, and what that refers to. All these cases that have names on, all these motions that have names on them, just so you know, they come from cases in which the legal doctrine was established. And so then instead of a long name, you just, it's a shorthand. Castigar hearing is a Supreme Court case, Castigar versus the United States. Frank's is another one. Frank's hearings refer to search warrants. And what they are is a request by the defense to have a hearing on whether the basis on which a search warrant issued was accurate. So in other words, the police may have probable cause based on an affidavit on what's said in the affidavit that they're going to find evidence that a crime was committed at a particular location, or they're going to find evidence of a crime by wiretapping. And I'm guessing here we're talking about wiretapping with regard to the Frank's hearing.
Joe, hang on one sec. Is this
Sure.
accurate? And look, I'm not a lawyer and I'm not that smart. So if you combine the two, there's always questions. But Deborah Jacobs here. Joel, the headline about the emails is that they're all attorney-client emails. Is that how you understood it, Joe?
As I understood it, Joel, the 100,000 that they're talking about were when Donna was represented by Rashbaum, or in that period before she tried to flee, before there was probably a formal representation contract, but he had represented her before.
But they're not necessarily all emails back and forth between. I mean, that would be crazy, right? They can't all be emails.
We still don't know whether and I don't remember what they said here, whether they said emails or they said, documents or whatever. But I thought that that's what they were talking about. And those, the defense claim might be privileged, and they don't know what the substance of the conversations were or the emails were. Those are the ones that the filter team reviewed, and the state has never seen either, because the filter team concluded that they were between lawyer and client, and therefore the state can't look at them. The defense says they want to look at them to decide whether there is evidence that they can use that when Donna said she wanted to go to Vietnam, she was acting on advice of her lawyer, and not that she had independently said, gee, I want to take a trip to Vietnam. Now, that's going to be hard for them, because at that hearing a few weeks ago, she explained going to Vietnam being Harvey had said, gee, we're under a lot of stress, let's go for a vacation for a while. She never explained it as, my lawyer told me I should flee, which would be, so it's going to be hard for them to make that defense. But what they're saying is they want to look at all of them to decide whether there's something in there that they can use to provide an alternative explanation for Donna and Harvey trying to go to Vietnam.
I just got very nervous. Anytime my mother or the COE give me a compliment, it scares me. And it just happened in the chat, Joe. So she said the lighting is good, of course. Not me, but the lighting, but that's still something. I have a lot of questions, Joe.
Now,
and
let me just say,
yeah,
it's hard
please,
for me
I
to
love
believe
it.
there are 100,000 of those, but that's how I heard it. But, if somebody heard it differently, I'm more than willing to be corrected because this went pretty fast. But as I heard it, those are the ones that the filter team reviewed. State never saw them. The defense said they didn't even know about them until Newland was deposed. And the filter team has held on to them this whole time. And
by the way, Joe, I mean, you always hear these terms, taint team, filter team. Like,
right.
Is the filter team, what is that in reality? Are those, is that a person in the state attorney's office that goes, like an intern that goes through all the emails? What is that?
It could be one, it could be a team. It depends on, the state or the jurisdiction. But the point is, if you are prosecuting, you are not entitled to know what the defendant talked to her lawyer about. Off the table. It's privilege. You can't see it. But there are a lot of tape recordings, or there might be emails. There might be all kinds of evidence out there. And you as the state don't know whether those are privileged communications. You can't look, but you don't know. And if they're not privileged, you may be entitled to them. So the process that's used is, they called it a filter team. You're right. Other jurisdictions called it a taint team. Is you have another set of lawyers looking at them one by one to decide whether they are arguably covered by the privilege. If that team decides yes, then the prosecuting team never gets to see them. That's the way it goes. And what they're saying here, and I see SP 74 heard it the way I did, that there are 100,000 of them that the filter team looked at that were never given to the state. The state hasn't seen them. The state didn't, in discovery, the state couldn't have given them to the defense because the state didn't have them. I don't know, and I don't recall whether Sarah said whether she knew that the filter team had some that they didn't have, but in any event, the defense said they didn't know that they were there. Now, Rashbaum would have known had he continued as the lawyer, because some of this happened when he was representing Donna. But that's it. So that's one set of things that the defense says they're entitled to review. And as I said, the one argument that Zelman made was they need to review them because there may be things in there that would go to explain Donna wanting to go to Vietnam other than consciousness of guilt and wanting to flee. That's one bucket of things.
Yeah, Everett mentioned sort of very much in passing, what was it, attempt to flee, or was it basically advice from her attorney, right? So let's just hypothetically say it's the latter. It's advice from her attorney. That would be Dan Rashbaum. Is that a problem for him?
Well, he said, and he said this to you when you interviewed him on that show a while ago, and assuming he described it correctly, that she had not been charged yet. She had not been arrested. There was no information that they were going to make an arrest. So she was as free as you or I to go to Vietnam or anywhere else. And that she said in that wiretap conversation, when the I think it was the drop call, that Dan had said when she had asked him, could we get away? He said, you might. Now that doesn't sound like it's direct advice anyway. Go ahead and flee. It sounds as though he's answering a question as to whether she would be able to get away in time. So even if the defense finds something in there that they want to use, it's certainly not a foregone conclusion by any means that there's only one possible explanation, and that is Daniel Rashbaum said to them, go now before you're arrested. And even if he said that directly, which frankly I very much doubt, but even if he said that directly, you still have her testimony at that hearing a few weeks ago, where she said, we wanted to go, we were just stressed out, and Harvey said, let's go away for a while. Let's get away. Let's get breathing space. So that certainly goes to undercut that her reason for leaving was that her lawyer told her to go.
Yeah. Justice Jane, this woman on the panel, her name is the Professor Joe Patuto. She knows her stuff and educates us. What is her name? Joe Patuto is her name. Professor.
Thank you, Justice Jane.
Yeah. Yeah, Professor to you. Sharon Kurland had a question, Joe. And again, I'm going to go through this because I have a lot of follow-up questions. But
Okay.
Sharon Kurland had a question about this attorney-client privilege issue. It seems Josh Zelman, the defense attorney, brought this up multiple times today in a 31-minute hearing. Why is he so concerned about attorney? One of the issues was where you were recording us at the jail. He seems to be overly concerned, or is that I don't know? Is that a proper concern for a criminal defense attorney?
Well, I don't know that certainly you can be concerned, and you might as well ask that question, get it answered. Because what if the answer is yes? Or what if the answer is no, and then you later find out evidence that it's not quite true? So it doesn't hurt to ask that question. I guess it surprised me a little that they asked. It sounds as though they might be a little concerned about it. I've heard Tim say that he suspected, at least at one point, that maybe a phone conversation of his with a client might have been overheard. So, it can happen. So he's got them on record saying no. And if in the future some evidence turns up that that's not true, then they've got a real issue out there. But other than that, I don't think it's a big deal. Attorney-client privilege generally, because if it's covered by attorney-client privilege, the state isn't entitled to have it or use it. So what the defense wants to do is try to figure out, is there anything from that prior representation that would be privileged and therefore not be able to be used by the state? And it's more than simply the state can't introduce evidence at the trial. If they had information they weren't entitled to know, in other words, Donna said, gee, Joel knows all about this. And then they go to Joel and ask, what do you know? They're not entitled to do that either. Because if they had not heard the privileged communication, they wouldn't have known that Joel knew something. So it's broader than exactly what the conversation was. You get back to the line from the conversation. If you found something out from a conversation you shouldn't have heard anyway, and then you did an investigation based on it, all that is off the table in terms of the state being able to use it. So they want to look at it. I guess if I had to guess, I don't think there's going to be anything in there that will be worrisome for the state, but you never know. And they clearly are entitled to it. I mean, the one place where I would have agreed with Zelman entirely is they have to look at it all to know whether they think there's anything in there they can use. It would be irresponsible not to look because they assume there's nothing there. And they can't rely on the state to say that, there might be 30 conversations that might have had some relevance. Not that law enforcement would be misrepresenting or that Sarah would be misrepresenting. It's just that they're representing Donna and they've got to give a fresh eye to it and their own perspective. And they may know something from what Donna said that would cast a different light on information the state thinks has no relevance. So they've got to look. There's no question that they're right, that the evidence that's surfacing now, they've got a right to look and an obligation to look.
Yeah. By the way, a lot of new members coming in. Thank you. Mina is one of them. Bling Chick here. And thank you for gifting that. Joe's going to like this one. She's Italian, so of course she's super smart.
Yes,
there you go.
do.
Just behind the scenes, so you know what's going on. There was a period of time up until about 5 minutes before where it was unclear if this hearing was going to be televised or not. So Tim Jansen was ready to come on only at 6. We're trying to get him on earlier. And Julia Jenae, who's a court TV anchor and an attorney who's covered this case extensively, she is supposed to join us momentarily. So, but you're getting excellent analysis from Joe, and I've got questions. One of them, Joe, I'm just curious your take on this. is Judge Stephen Everett. Jared Ross was in the chat. Shout out to Jared.
Hi,
He lives
Jared.
he lives and works in Tallahassee. And right off the bat, he said Judge Everett, who's like a jovial, amiable kind of guy, that right off the bat he looked irritated and annoyed. Did you get that same sense from Judge Everett today?
Well, I didn't, the camera wasn't on him very much, but I would be very surprised if he wasn't irritated and annoyed. When you want to get this thing going, when you already had, a catastrophe last fall, when you told everybody it's going to go on June, whatever that date was, date certain, no playing around, and you could have held them to that if nothing new had shown up that was out of the ability of the defense to locate earlier. But now what's happened is there was a new investigation in October, and they say they have to look at it. They say they didn't know about the filter team that looked at the earlier conversations, recordings, whatever they were, and they need to look at that. I mean, to the extent they didn't know about either of those, and I think one thing came in a couple of weeks ago, if I were he, I'd be irritated, not at the defense for raising these things, and not at the state for, finding them or providing them in a timely manner, but so late, but just irritated that here's where we are. Neither side is doing anything untoward, and nonetheless, it looks as though the trial date may be jeopardized.
Look who is here. Look who is here. There he is. The man with the greatest hair in America, R. Timothy Jansen. Tim, you weren't in court, were you, Tim?
I was.
Oh, you were. All right. Well, tell us.
I was with the media. I was in the court. Yeah.
Look at this. You got a court insider right now, courtroom insider. So, Tim, the headlines here really are, you were right, but off by about 15,000, 100,000 emails. But what struck me even more is this investigation that Sarah Dugan talked about that was started back in the fall. What's the bigger headline here, Tim? What did you take away from this?
Well, the bigger headline is the Title III wire that was signed by a judge February 21st of this year, which means it was probably new charges. A confidential informant gave them information that a crime was being involved. And to get a Title III wire, a judge usually requires you to do every other investigative technique before they give you a Title III. So a Title III was given, so it was so serious and involved certain parties that they didn't believe they could infiltrate, or so it was, but it's pretty serious. It was probably either witness tampering, obstruction that they were looking into.
Tim, you're buffering a tiny bit. I don't know how far you are. I know your house is a little bit away, but we might be better off.
I'm in my car.
Are you headed home or?
Am I losing you?
A little bit, yeah. If you can get us once you're home, Tim, we'll still be going.
How long are you going to go for?
Until you're back, Tim.
Okay, all right. I'm only 10 minutes from home.
Okay, awesome. Just log on when you get there. I'm going to bounce you out. Thank you. So, Joe, can you just expand on this a little bit? This Title III wire, this is now lawyer talk. What is Title III versus Title II versus Title I?
Yeah,
what does this mean?
Titles, I don't know that I call them chapters, but in a statute, you'll have Title IX, or, it's the name of the part of the statutes that you're looking at. And Title III, I believe, is electronic surveillance. I'm not sure, but I think that's right. Tim will be able to tell, because I'm not sure whether he's talking about a state statute or a federal statute.
And then do me a favor. So, he said that this Title III wire was signed and he thinks something to do with this confidential informant. What did you gather about that, if anything? I mean, at one point, we heard from the defense side that they had two people behind bars who were allegedly on drug binges, had been released, but had information help Donna. But this sounds like something totally different. This sounds like something that would benefit the state. What, if anything, did you make of this information?
Well, a Title III warrant, at least the federal statutory number, and it may be the same state number, is the authority to wiretap. And what Tim was talking about is you don't get authority to do that unless there's no other law enforcement way to get the information you say you have probable cause to get. Because we think that, an interception or or listening to somebody's conversation is the strongest invasion of privacy of any ways that the state can get information. Tim went on to say, and I think you're going to have to ask him for more on that he thinks that the Title III warrant or intercept order that issued suggests that you've got witness tampering or obstruction of justice, and that's what they were trying to find out by virtue of the the statute calls it interception of communications. It's really listening to people on the phone or using a bug. It's listening to conversations. So he was suggesting that the February order, I can always get a wiretap order. I think you're going to talk about committing a murder, conspiracy to murder. I think you're in a drug, enterprise. I think you're the mafia. I can get a Title III order. He was suggesting that the reason for this one was that the state said they had probable cause to believe that there was obstruction of justice or witness tampering. And that you're going to have to ask Tim why he thinks that was the focus of the Title III order in February. I don't know, and I wouldn't even want to try to guess. And I think he's right. That's very important. But I think equally important is the investigation they did in October and the fact that they think they've got at least one or two things that they want to use on the state side. I think every time you get a little more information in these cases, particularly, there's it's not a case in which you've got direct evidence. Nobody saw Donna order a hit. With circumstantial cases, the more pieces you have that you can put together, the stronger the case becomes. I think the case is already strong, but still.
Is it also possible that it relates to someone other than Donna, or AKA Harvey and or Wendi?
The evidence that they find can relate to anybody.
Mhm.
So if I've got an order and the order says Joel committed murder, it doesn't matter that what I was doing was prosecuting a drug case against Nancy. Now I've got evidence against you. The purpose for asking for the intercept order, it's harder to think it might be Harvey or Wendi because this is Donna's prosecution. And we're in February here. There's nothing to indicate there was an active investigation going on of Donna or Wendi. Now, could it be that they are not Donna or Wendi, Harvey or Wendi? Could it be that they wanted to capture Harvey's conversations because that's where they think they're going to find the evidence? That's entirely possible, at least theoretically possible, because you can enter it against anyone if you've got probable cause to believe that's where the evidence is. In other words, if I think you've committed murder and that you hid the gun in the COE's car, it doesn't matter that I don't have any reason to believe that she's committed murder. If I have probable cause to believe that there was a murder that was committed and I'm going to find evidence, in other words, the gun in the COE's car, I can get a search warrant to search her car, even though I don't have any evidence that she's done anything. Works the same way for a wiretap. If I think there's going to be information that people on a phone call are going to talk about, and I've got probable cause for that, I can tap someone else's phone, even though that person is not the suspect, not the target of the criminal prosecution. So, could be evident. And then once you do it, so I say now I want to get evidence. I think there's going to be evidence of who knows what, a murder that I'm going to hear on the phone. And when I hear that, I hear information that's completely extraneous to that, but it's also evidence of criminal conduct. I can use it. It's called, quote unquote, plain view. If I'm where I'm entitled to be, and here I'm entitled to be there because I got a court order that says I can listen to the conversation. So I'm entitled to be there. And then I hear something I never expected to hear, but it's evidence of a different crime by this defendant or another defendant, another person who might have committed a crime, I'm entitled to use it.
Now you know why they call her the professor. Look at this edge of the ledge, 4 a.m. here in Siem Reap or Reap, Cambodia, hanging on till dawn, if need be. Edge of the ledge. I'm actually thinking of moving the family to Cambodia. I feel like it would be much more down to earth. Let me know how the Wi-Fi is there. survivingthesurvivor@gmail.com. And by the way, you could have been neighbors with Donna had she made it. But I'm curious about life out there in, I guess, Southeast Asia. Tiger Lily wants to be Joe in her next life. She's fabulous. Great coverage and discussion. I don't even have to discuss. I just let Joe go. But Joe,
very kind gifts. That's all I can say. Very kind people in the chat.
yeah. By the way, someone made a very astute comment. They're like, Joe knows all, but yet she's not a know-it-all. I think that's pretty accurate. That's great. So let's just go through Josh Zelman here. He got up a little bit sheepishly, I might add. He's talking about this, basically this motion he filed back on April 21st, which is to get this continuance in sort of a rushed manner. This is where it comes out that the state conducted this additional investigation. Sarah Dugan points out that they obtained additional records, but now he said the state didn't hand over this stuff. And then Josh Zelman went on to say, we were basically asked to trust the state without being able to verify. I guess my question, Joe, he's taken a shot at obviously the government and they fired back. I mean, how commonplace is that, I guess? Is Zelman, to a layperson like me, it sounds like he's accusing the state of some shenanigans, just playing hide and seek with some of the discovery.
Measure him against Daniel Roshbaum, who was taking shots like that all the time. I don't think it's, and I've said this before, I don't think it's a productive way to make arguments because you can get to the same place by saying, we just need more time. We understand that they didn't delay, nothing nefarious over there, but however it happened, the impact on us is we need more time to look. So if that's what he's doing, he was mild compared to other lawyers I've heard do it. And certainly if you go back and listen to some of the hearings with Daniel Roshbaum or the trial, I mean, he came out, really shooting with both barrels a couple of times, accusing the state of acting poorly. He had one where he said, why they're trying to do this. They're doing it for this reason. He had no reason, no reason to say it. I actually thought Zelman, I took a shot at him the other night saying that I thought that these lawyers have not been crisp and succinct in their arguments. And I thought he was, much better today in terms of staying on point and making the arguments that he had to make.
Yeah. So just continuing on here with Josh Zelman, he gets up in front of Judge Everett and basically said, look, months ago, I asked the state for everything. I did not get everything. And then he brings in the 100,000 emails. Then he said, Joe, to Judge Everett that they actually enabled some kind of software, which I presume is some sort of AI software to sift through the emails. But he acknowledged, he goes, it's not working too well. And so they brought in some kind of outside team to go through these emails. I mean, Joe, it's such a novel thing still, but would you trust AI at this point with sifting through discovery?
Well, I'm what they call a Luddite. I don't trust technology for anything. But I thought he was talking about their inability to get in to even read it themselves, not on the 100,000. But he was talking about some of the more recent things that he said they haven't been able to read. I thought that's what he said. And they were looking for other software to help. It may be that they want the, AI or some sort of software to sift for them. I mean, if they use it, for example, to say, sift it so everything from Daniel Roshbaum is in one list. Anytime the word Vietnam comes up is in a list. That I think you could, I would be comfortable trusting software with, but you're still going to have to go in yourself then and read it and draw conclusions from it. But it could help you, if you've got a pile of 100,000 things, it could help you at least sort it into, into piles.
Yeah. Georgia OKC, longtime community member here. I'm recovering from surgery. Hope you're feeling better. The show is just what I needed. Happy to be here. Hope you're feeling better. Poetic Justice, about my comment about Zelman looking sheepish. You look like a lamb going to slaughter. Sorry, Josh, if you're listening. We're a tough crowd. To Charlie, I'm reading a comment from Kosher Style. It's interesting. Joe Patuto, another thing that caught my attention for at least for a minute was Josh Zelman explaining to Judge Everett that there are also a bunch of new Celebrite extractions. For those who do not know, Celebrite is kind of the gold standard in cell phone data information. So he points to the fact that there are these new Celebrite extractions specifically from Donna's phone, but then in the next breath he says that the state doesn't really plan to use those extractions, but we might want to.
Yeah.
What do we make of that?
Well,
that there are these findings, but the state doesn't necessarily. Is that a nothing burger?
Yeah, I thought, and Jill, if you heard it differently, again, it just went so fast and there were so many different things they were arguing about. But I thought they were talking about the discovery or what was discovered from that investigation in October. Whatever the evidence was that was discovered then, because Sarah said law enforcement has reviewed all of that and they think there are only about 30 that are relevant. We've looked and we think we'd only use 1 or 2. We really don't think there's anything there. And he said, that's fine, but we need to look because we've got to make an independent determination. So I thought that's what that referred to. And again, to the extent that's what he's talking about, he's absolutely right. They've got an obligation to defend Donna zealously, and it would be irresponsible to accept a representation. It doesn't mean you have to think they're misrepresenting or lying or hiding something or not telling you all of it, but it still would be irresponsible for a defense lawyer to rely on it rather than do his or her own investigation. I mean, think of it, Joe, if you hired a lawyer and the lawyer said, gee, we didn't look at all those records because the state prosecutor said there's nothing in them, you wouldn't be a very happy client.
Yeah. By the way, the one name we did not hear today was Dan Markel, which is really what this is all about. And someone was asking earlier on, does this impact or affect the Markel family? And the answer is yes, it does, adversely, because they are now being dragged through the mud as this continues to likely be stalled till the fall. Before I forget, too, if this is continued, which it likely will be, please, at your earliest convenience, email us, survivingthesurvivor@gmail.com. Let us know a trial. It has to start in the next 3 to 4 weeks, whether it's Diddy or something else that we don't know about. Email me. I'm going to go cover a trial. Let us know what you want. Look at this, Joe, from Edge of the Ledge in Cambodia. The Wi-Fi is excellent. My phone service with 25 gigabyte data, which I have no idea what that is $4 a month. Time to move. Edge of the Ledge. I might come out there, just do a week's worth of podcasts and then try to convince the family to move out there. I bet you the cost of living is quite affordable. Look who's here. Look who is here. Back. Tim Jansen. Can you hear me?
I can.
Oh, beautiful. So Tim, was Judge Stephen Everett annoyed? He looked it.
He did. He actually did. And it was interesting. A lot of things came out today that I think are important. There was some accusations being hurled by the defense. Some of them, the state had to respond in a short answer. No. Have they been monitoring our legal conferences? That presupposes and infers that their telephone communications have been recorded. Because if they're asking if their conferences have been recorded, it infers that maybe their communications by phone have been recorded. and the state said no. She didn't respond by saying, no, we would never record. All of that is not recorded. We do know this. We know that Donna has been talking in the jail. The state has witnesses. Okay. The defendant has their witnesses too, but the state has witnesses. And that's another issue that the defense was asking. They're not complying with the rules, Judge, that require them to turn over jail informants, plea deals, criminal histories, any favors they've got if they've ever testified in the past, because they want to impeach these witnesses. So Donna's been talking, and the state's going to call witnesses to impeach her.
Yeah.
And you saw the one part, they talked about these calls not being relevant. And then he said, well, wait a minute. If it's got counsel, it might be advice of counsel. So that might be relevant. And the judge goes, well, that's hearsay. How would that be? Your client can testify, or you can subpoena, if someone waives the waiver, you can subpoena the lawyer to come in there and give you, you don't need these. He goes, well, we don't know, Judge. It still may be relevant. He may be right and he may be wrong, but it's something the judge has to consider in deciding whether to give him more time to go through them.
Yeah, Tim, I mean, what's the bottom line? Is this going to get continued? And if so, until when?
It's going to be continued. When the defense lawyer in a murder case says, I cannot comply with the rules to file pretrial motions on my murder client because the state has not given me information, and then they bring a new investigation to our attention that we have to drop everything, he has to grant the continuance. My guess, and this is just a guess, he's looking at his vacation schedule, talking to his wife, and finding on his calendar times that he can set. He says a 2 or 3 week trial.
Yeah.
And
He said, by the way, Tim, I know you know this. He said there's only a few points in the year where you can have a 2 to 3 week murder trial, and who knows, it could go longer. Charlie's was only 8 days. But Tim, what are those 2 or 3 points? I guess the fall after the holidays, right?
I would think we're looking at August or September. Those are the dates I'm thinking, because he gave him till May 16th, the next deadline, right? And Josh said 3 months. So you look at 3 months, and we're in May, June, July. August is 4th month, and September is the 5th month. The judge, he does this. If you ever seen, I can tell you, I know this judge. Whenever he issues rulings of substance that he wants to take his time and do it properly and have the motion worded properly. The key question he asks the state, if anybody caught it, what prejudice do you have if I continue this trial? And she says, we don't have any prejudice.
Right.
What prejudice do you have, defense? Oh, my murder client is going to have violated her due process and not be ready for trial. Well, you know where the scale goes. That blind justice is going to lean towards a continuance.
Yeah. Joe, to you, and I see Julia back there. I'm going to let her in just 1 second. I just want to give her a second to set up. Julia Jenae from Court TV will be here in a moment. This was a jam-packed hearing today. Just back to the Judge Everett issue, Joe Patuto. So he looked annoyed, but you heard Tim say in a murder trial, the defendant cannot be denied the right ever, but particularly in a murder trial, to a fair trial. So in essence, he kind of has his hands tied. Like, he has to allow this continuance to happen. How frustrating do you think that is for him?
Well, I think he's frustrated, but he's also a pragmatist, and he knows that, as I said before, it isn't that he can direct his annoyance at either the state or the defense. It doesn't appear that either side was doing something illicit or unreasonable. It's just the situation. So he's frustrated about it. He's going to have to go take a walk or have a shot of Bermud or something and calm down, and then he'll be fine.
Here she is, Julia Jenae, the other professor, even though she's not a real law professor, but she might as well be one because she hosts a show on Court TV and she is a lawyer. Julia, the two real big headlines, and I'm not sure if you actually saw the hearing or not, so I apologize, but it was 100,000 emails apparently that the defense just got, but also they revealed that there was a new investigation that was launched back in the fall, and that has me very intrigued. Any thoughts here on what that could be about?
Yeah, I will say I did not watch the hearing live because we at Court TV were inside of the Karen Reed trial
Mm.
at the time.
Who's
But
who's that? I never heard of her.
exactly. That's where all eyes are right now. But
Mm.
I did see the notes from that hearing because we, of course, are still on top of what's happening and ready to go for this trial. And I am curious if the date is going to get moved. I do think it's possible because I think Judge Everett doesn't want any issues on appeal. But I'm pretty shocked that there's this much in discovery that her attorneys don't have. And when I saw the words jailhouse informant
Mhm.
in the arguments or in the notes that I was reading, that has me really intrigued as to who these informants might
Do-
be. We know there
I,
were some
I,
with
I
Donna.
mean, Julia, I know it's all speculation, but give us a guess. What if you had a guess here? What do you think it leans toward?
Well, there's been a lot that's been brought up in terms of Donna coming to the court talking about who she's been talking to, people that she thought thinks helps her case when it comes to people who have either been harassing her because she wanted to get out on bond, or she mentioned that there were people who were talking to her about Catherine McBanawa and that they confirmed that McBanawa said that she set the Adelsons up. So I wonder if there was investigation into those and that led to other people inside of the jail. I don't know. But that's my guess that there's something that's happened during the time that she's been behind bars, perhaps, or even, I mean, it could go so far as to Charlie.
Yeah, or Wendi or Harvey, maybe. Who knows? One of the things that we haven't really talked about, and Julia, I'll let you hop in on this and then get Tim and Joe's take on it too. Apparently they subpoenaed Harvey's Zelle account, which if you have a bank account, there's a Zelle app or feature within the bank online banking that allows you to send money back and forth. How relevant is that, Julia, in terms of investigative material?
Oh, it's huge when you have a paper trail of money trail. The money trail is huge in this case because it's all about the money, who sent the money, especially when we're going outside of just the actual people who killed Dan Markel, when we move to Catherine McBanawa and then move even further to Charlie. And then if we want to implicate in terms of the state, and they do want to implicate Donna, they've really got to make those connections with the money. What was she paying out? She was writing the checks that went to Charlie and to Catherine McBanawa. So if there's if there's money being wired through Zelle from Harvey and it's going to anything involved in this case, which I would imagine if it's part of discovery that it is, I'm just very curious as to what all it's going to be in front of the jury, because perhaps there's been things in discovery that we haven't seen yet in an actual trial.
Yeah. Tim, there's a question. This is it right here. Moose in the City here, Tim. Could this wiretap, and again, we're learning about new wiretaps, which is fascinating. Could it be Rashbaum and Donna still talking after the fact? Interesting question. I want to be careful here because I don't want to, Dan Rashbaum's taken tons of heat. And now he's sort of out of this, so to speak. But what are some possibilities here, Tim?
Well, I think there's no chance at all that Rashbaum is talking to Donna. If he is, he needs to get a lawyer quickly and talk to his partners, because that would be a major mistake and could threaten his bar license, I would imagine. I believe that they're inmates who are talking, and Donna has been talking. I've got sources that Donna was talking about the trip to Vietnam. She was explaining the trip to Vietnam. And some of her explanation was completely inconsistent with a vacation. It was purposefully to evade getting arrested and stay away, so there was no arrest. Now, I know there was a couple inmates that got close to her, and my understanding is wanting to cut a deal. So I think that might be one of the informants or jail inmates that are going to be testifying. I'm not sure that's related to the wire, though. That wire may be something else. They may have uncovered it. And I'll tell you, they listen to these phone calls and these emails that are sent. And when they get a pop up and there's somebody probably in the office monitoring all of her calls and all of her texts, emails every day. And if they come across something, they probably jumped on it and then tried to do some investigation, went to a judge and said, Judge, listen, we cannot, there's no way we can infiltrate this. There's no way, we need a Title III wire. Judges don't like to give Title III wires. The state of Florida doesn't do, the state here, state attorney's office doesn't do a lot of Title III wires. Statewide prosecutor does, the feds do. It has to be a murder case, but this is a murder case. And so for them to admit in open court, February 21st, there was a wire signed, something significant was happening.
I'm just, Tim, what do you, not clear with that. I see Harold, anything but Dell's got a comment. I just don't fully understand it. So Harold, reissue that comment. There was Joe Patuto. I'm leaving Tim out of these right now, but there was just a comment up. And there's always this speculation. Is Donna doing this intentionally? Which I don't think so. But basically the implication is she buying Wendi time if Wendy's now in trouble. Number one, Donna wouldn't really know, right? And number two, I think Donna's out to save Donna at this point. What do you think?
I agree. She's just chatty. I mean, you would have thought that she wouldn't have had those conversations with Charlie back when, but you certainly would have thought after those came back to bite her that she wouldn't continue to have conversations that were anywhere within 1,000 yards of the events leading to Dan Markel's death or the aftermath or her prosecution. But seemingly, she just can't keep her mouth shut. She's got this impulse to talk. And I think that's what we're getting. More evidence that she just can't, keep her thoughts to herself.
She's what they call a yenta. You can look that one up in the Yiddish handbook. Super Planner Girl. She helps us behind the scenes. She's in the comment section. La Mesa Filipino Food Club for Julia here. This is interesting. How complicit does the panel see Harvey being? Allegedly, it's wild to me. When this first broke, I assumed Harvey was in the dark. Now, 10 years later, I've completely changed my opinion. From day one that Carmen's been on this case, she says Harvey knows everything. Julia, is there a chance that some of this new discovery, this new evidence maybe leads Harvey's way?
That's a possibility. He's already in what I feel like is hot water when it comes to the money exchanges. His Lexus ending up being, was it a Lexus that
I believe
was given? I know it was a luxury car.
It was. It was.
Yeah, that Catherine McBanoa ended up buying for a steal. And it's his dental practice that this money is being funneled through. So I just have a hard time believing that he had nothing to do with it, but I think his family is smart and they know the more compartmentalized this is, that the better they protect themselves. And unfortunately, it has worked up until this point. The way that Charlie kept it away from his family meant that they went 10 years before the first Adelson was convicted, and then now Donna Adelson being arrested. So Harvey's involvement, I mean, I haven't seen it through the trials, but in the evidence that's going to come out in these trials, it's usually going to be focused on the person who is actually sitting at the defense table. There's going to be restrictions on how far they can go into bringing in evidence. So is there more on Harvey? I think there is. But looking at him now in the airport when Donna's being taken away, he looks like he's kind of clueless about everything, and she's the one having to take care of him. But let's be real, it's been 11 years since this all happened. And if Wendy's comments that are, the prosecution says, meant that his birthday gift was Dan Markel's murder, which is really sadistic to think about, but that birthday party was right in the middle of all of this. So very curious, very curious.
Julia, I got to put you on the spot. So I need a trial to cover outside of the Karen retrial. Any recommendations coming up in the next couple of weeks?
The Maxwell Anderson. Well, no, that's not coming up in the next couple of weeks.
Is that the first date murder one?
That's the first date murder trial. Next couple of weeks is this one. This is the one that's on the docket. And if it doesn't get
continued,
if it gets moved, but we'll have plenty of them. I don't know what big headline other than, Lori Vallow Daybell, her second trial with
Yeah.
Brandon Boudreaux as the victim. Is coming
Yeah,
up soon.
that's coming up too.
Mhm.
Mandy Strong, Tim Jansen. We're hearing about jailhouse informants here, possibly helping the government's case. But Mandy has a good question. What do juries think of jailhouse informants in general? By the way, Luis Rivera happened to be probably the most credible witness of all.
Well, he wasn't really a jailhouse informant. He was a co-conspirator that participated. Jailhouse informant is someone who wasn't a participant, but just happens to be in jail with the defendant, has information that the alleged defendant told him. It depends on the information that they have. It depends on the relationship. If they can prove that this defendant was getting any kind of canteen money from Harvey and became really close to Donna, and then has information that has not been released and it's consistent, then it can be very credible. Now, if it's just Donna told me this or told me that, yeah, they're not that credible. And jury instructions tell you to weigh them with great caution because they're trying to curry a favor. Depending on what they're in for and how much kind of a favor they need from the state, that's also something that can weigh their credibility.
By the way,
the interesting thing about that is if Julia's right and there are informants on both sides, then some of the ways that lawyers argue against the credibility of informants is probably going to be muted on both sides because, you can't say, gee, they're in jail and they're looking for a deal or they're, because each side's going to have one or two or three or whatever. So it'll be interesting to see if they end up with both sides having somebody, how they navigate it.
LeBron Jane, love the name. Know where I'd rather be on Wednesday afternoon than with STS or Court TV. Best guest in the absolute best community. Justice for Dan Markel. Thank you so much for that. As Harvey sending Donna's inmate friends who may testify for a catch through Zell. I'm not even going to go there. Julia Jenae. So 32 hours, they mentioned, was a number worth of these new wire calls. But then Sarah Dugan got up and showed her hand a little bit, saying that there's just one, I think either 1 or 2 hours or 1 or 2, which would be a big distinction, but one or two hours, one or two
I
calls.
think it was just 1 or 2.
Okay. Yeah. That she would use. So what does that tell you, if anything, Julia?
I just want to know what calls weren't turned over during discovery at the beginning of this. That means there are calls that didn't come out in Charlie's trial that weren't turned over to his attorneys because Daniel Rashbaum would have everything that they intended to use there. So that would mean it's a call perhaps that doesn't have Charlie on it. So is it a wiretap with just Donna and Harvey and wouldn't have been relevant in Charlie's trial, so they didn't turn it over? And why now? We were going to trial in November. So I'm just curious. That's a bit concerning if they are just now, if I'm understanding correctly, if they are just now turning those over now, why was that not turned over before? Even if they weren't going to use it, if it's in any way exculpatory, then it has to be, or something that they could use.
I can answer that. They had some sort of tip in October, and they started a new investigation.
Okay,
and
so these are more
30
recent.
hours they're talking about is the consequence of the new investigation, not anything that went before. The 100,000, so far as I understood, and there were a couple of people in chat who heard it the same way, were whether they were emails or calls or whatever, but they were items that the taint or the lawyers looked at because they might have been subject to attorney-client privilege. And Sarah said the state never got them. The taint team kept them. And there might have been some misunderstanding about the new team knowing that they existed. As I understood it, Daniel Rashbaum knew that they existed. So
Tim, when the taint team works, it works. That's a good thing. It's supposed to be that wall.
Tim, the professor explained this, but Lee T, can Tim explain Florida Title III, and then this comment from Brady Starr? What about money being sent to Magbanowa from Adelson to keep her quiet, Donna talking in jail, and then the Title III wire? What is this Title III wire? How does it differentiate from other wires?
Well, it's electronic surveillance, and it's the most intrusive that we have in the Constitution. Judges are really reluctant to give it. Normally, the investigator has to do an affidavit, has to be very experienced. He has to outline all the steps they've taken, the traditional investigative steps they've taken, and that there is no other way to proceed with the investigation. The investigation has stalled. If you remember, they went through this for the wiretap down at the restaurant, and Dan tried to exclude that, saying the information was stale, and Judge Hankinson ruled against him. But a Title III wire is not easily given. It's got a lot of limitations. It's usually for 30 days only. You have to report back to the judge. You have to have a filter team so that the prosecutors do not get anything, because sometimes someone falling asleep, attorney-client information will get in there, and if you don't want the prosecution to hear things, so you have a filter team. They're supposed to filter it, make sure that whatever is relevant sent to the prosecution does not have any attorney-client privilege.
Yeah. From some nobody, I love that name. They wouldn't need, Julia, this is a great distinction. They wouldn't need a wiretap for jailhouse calls, right? So does this imply that it's Harvey on the outside? Not necessarily Harvey, but is the implication or the fact here that it is has to be people on the outside?
Yeah, it would have to be a private. Oh, go ahead, Tim.
Julia,
go ahead.
Julia,
I'm
go
sorry.
ahead. Go ahead.
Oh, I was going to agree that a wiretap wouldn't be on a jailhouse phone call. It's recorded. That's how they already have the jailhouse calls that are already in evidence in this case. So it would have to be something they'd get between two private individuals that they couldn't otherwise record. I can't remember if Florida is I think it's a two-party consent.
Two-party state. Two-party.
So if anyone involved, if anyone went to talk to them and got information, they would still need that. But who's out? Harvey, Wendi? But it could be someone that we're not thinking of who had information relevant, but it would need to be connected, I would imagine, in a way for them to get a warrant for a wiretap.
So the judge asked a key question, asked the state if they were going to supersede the indictment. Right. That means additional charges to Donna. So the wiretap information investigation pertained to possibly Donna. Who is Donna talking to? She's not talking to Wendi. She's not talking to Charlie. She's not talking to Robert. She's only talking to Harvey and only getting visits from Harvey. So I would infer that Harvey has to be part of this wiretap.
Wow, that's a very interesting point there, Tim Jansen. David Van Dyke, back to Tim. Could an inmate see a big opportunity to reduce jail time by being or seeking Donna's best friend status, specifically for lowering her sentence? Maybe Donna's friends aren't all sincere in jail. Who knows?
If you go to federal prison, they have a thing called the C bus, jumping on the bus. Every defendant in there is trying to get information to reduce their sentence. They become friends with people, and they say, this guy confessed to me, so they can get their sentences reduced. In federal court, it's everywhere. State court, not so much, unless it's a big trial like a murder trial.
What do you guys think of the Diddy trial, by the way? That starts next week. The reason Julia probably didn't mention it, there's no cameras, no electronics.
We'll be covering it every day, though.
Yeah, and I could go and cover that, thanks to a good friend of mine who just offered up his place downtown. So 4 blocks from the courthouse. So let me know what you guys. Your wish is my command. Let me know, and I will. I'll do whatever trial. survivingthesurvivor@gmail. I'll sift through the emails tonight. Let me know, Julia. I asked Tim, I asked Joe, and they no one likes this question, but does Wendi have reason to be nervous this evening?
I would say yes. Because I have been on the team of, Wendi has nothing to worry about. They're just going to end with Donna. This is the last one. But this information has me thinking that they have something more, because these taps have to be on people who are out, who's left that's out. And even if it adds to Donna's charges, we don't know if it could add to someone else's charges. So I would be concerned. It's been a long time. Loose lips sink ships. So who knows who's been talking and saying more things than we've seen in the past.
Yeah, that is for sure. We're going to go a few more minutes. I know everyone's got places to be, but me, Harold, anything but dull. 30, Tim, just reiterate, is this 32 hours of wiretap calls just since February? Is that what was said in court?
It sounds like it was 32 hours, and Josh said he was barely able to get through 2. So I thought Josh, they're trying to be very core because they don't want the information in the investigation in the affidavit for the wiretap to be released. So something's very damning there, very damning that they want that still sealed. So I guess they think that might taint the potential jury, even though there's no new charges coming forward.
Joe Patuto, I'm just thinking here, and obviously we've addressed the chattering issue among the Adelsons, but if you're in jail, your calls are being recorded. But if you're the Adelsons, you got to think you're being wiretapped at all times. What on earth would possess them to say something incriminating on a phone call? Is it just this like I don't know, suspension of disbelief that you're being recorded and they just assume that they're not, and so they start talking?
I've quoted Edgar Allan Poe before, the imp of the perverse. You just can't help saying things. And that would be, there's no rational explanation for talking when there's even the potential of being overheard, or you're talking to somebody else who might tell people what you said. There is no rational explanation for it. So it's just this inability to keep things to yourself.
Yeah. Lady B here, how different, this is a fascinating question. Tim Jansen, I'll have you and Julia weigh in and then we'll get some final thoughts, but how different will this trial be, Tim, and in what way than Charlie's trial?
Well, it's going to be clearly a circumstantial evidence case. There's no direct witnesses going to come forward. Maybe Catherine's going to say about paying them, but no one's going to come forward and say that Donna told me to do it. Donna paid me, like Catherine had with Charlie. She got the money from Charlie and so this is a circumstantial evidence case. I think she would be a more credible witness than Charlie. Charlie rehearsed too much. He was too prepped. And Donna's a lot more clever, but Donna's biggest downfall is going to be her fleeing the country. She will not be able to explain that. You saw today that they may try to argue on advice of counsel. So are they going to bring Dan Rashbaum in to come testify that he advised her to go or she could go? We'll see. I don't know if Dan's name is on the witness list. Do we know that by the defense?
I haven't seen it. STS, let me know. I have not. Julie, have you seen it? I have not seen
I haven't noticed it, but I don't know if there's been an updated list.
Yeah. A lot of trials continued, by the way. Marta Fonda here letting us, I was supposed to be at Corey Richens' trial right now, the woman accused. A lot of people are asking me to do Brooks Hauk. We'll take a look and we'll make a decision. Crystal Rogers, is that the same case, Julia? Is that the
Brooks Hauk?
Okay. Same as, okay.
Mm-hmm.
Shows you what I know. Julia, someone comes up to you today and they say, hey, I missed Donna Adelson's hearing. What is, in your opinion, the 2 or 3 most important points of today's hearing?
Trial may be continued. Jailhouse informants may be coming into the courtroom. I mean, that would be new. We didn't have any snitches in any of the other trials. We had a lot of people in jail clothes. We had Luis Rivera, we had Sigfredo Garcia, we had Catherine McBanawa, people who are in jail, but no one who says, I overheard this, I overheard that, or we got close and she revealed to me that this happened or that this was a setup or whatever the case. So that's what I am taking away from this hearing so far.
Look at this. Please go up to New York and cover Sean Combs. Tim Jansen, your takeaway from this hearing. Tim was there today. Obviously, Stephen Everett is frustrated. His poor wife's going to have to listen to him tonight, although I have a feeling he's a lot less annoying than I am. But Tim, what is your takeaway?
Well, I think it goes to show that the state is not done investigating this murder. They went to the point where they were going to do it. They got a Title III. They followed some leads, some information, got a wire and proceeded with it. I think that bodes well that they're not just sitting there preparing for this trial and letting potential leads and new information and evidence go by the wayside. So it could pay off in the long run. We don't know.
Yeah. Dr. Reinhardt, good to see him here. Joe Patuto, this question and your final thoughts. Does Donna have any good options on cross-examination? Her emails and recordings are going to haunt her, and the cross will be brutal. Do you agree?
Well, I'm probably a little biased, but I don't think she's going to hold up as a witness. I don't see where she's going to have some strong position. I guess the thing that I think might be on her side, except I don't think I'd be persuaded by it, is if she looks like this poor little old lady who didn't know what was going on and was used by her family. And I don't think she can pull that off. But otherwise, I can't imagine what would help on cross for her or on direct for her.
I lied. I have one last question for everybody. 2 questions. Julia, is this trial delayed? And will Wendi eventually be indicted?
Is this trial delayed? Yes. I do believe that Judge Everett is going to take every precaution in making sure this doesn't have an issue on appeal. And he knows that Donna has had new attorneys, had everything turned upside down in this case. So I don't think it hurts anyone for this to be delayed. Of course, in terms of, what was your second question? Whether or not
Wendi gets indicted eventually.
As I said earlier, I did not think that there's enough evidence out there for her to get indicted. And just because she's been faithfully coming in to the courtroom every time the prosecution wants her, I felt like she's not going to be someone who they are going to pursue indicting if it's out of respect for her boys and the life that they, have been subjected to living. Whether or not she knew or not, I don't know if they have enough evidence to show that she firmly knew, but I don't know. This new stuff makes me think there could be a possibility. I do want to throw in a plug for you on your trial list.
Oh,
again,
please.
in the comment section.
Please,
the Rebecca Auburn case.
Okay.
It just got rescheduled for May 20th. And this is a sex worker who's accused of luring men in, drugging them, and killing them. And
where is it? Do we know?
As well. It's in Ohio.
Ohio. That's a good
Franklin
place.
County, Ohio.
There you go. COE. We'll discuss later. Thanks so much. Where was this comment? This is Joe Patuto. This is very fascinating to me. I promise we're winding up here from Purple Coconut. Maybe Harvey's talking to Wendi. That option hasn't really come up. We could keep thinking Donna to whoever else, but it could be Wendi and Harvey. And I'm sure that the two of them are still talking. If there was a photo a few months back of Harvey, this is before she moved to Austin, of she and Harvey at either a Whole Foods or a Trader Joe's. So they're definitely in contact. Is this a possibility? Is the trial continued? Will Wendi be indicted, Joe Patuto?
Yeah, it's a possibility that Harvey is talking to Wendi, but I don't think Wendi is saying anything that would incriminate her. Yes, I think the trial will be continued. And I have felt for a while that Wendi would be indicted. And I've said for a couple of reasons. One, at the end of this trial, they'll have all the information I think they'll ever have against her, and it's going to be a Fisher cut bait. And I think looking at the evidence in the light most favorable to the prosecution, the state can make a reasonable, honest, objective conclusion that the case can be prosecuted and there can be a conviction. And I think that's what they have to do. I also think that with regard to Wendi, we don't know. First of all, we have Sarah Youssef, and we don't know what her evidence will be. Julia talked about what other evidence might come up now with the new wiretap and the new investigation. And also, I don't know that we can conclude from Georgia's direct examination of Wendi the last couple of times what the state might know, because they have to be very careful, since she's got use derivative use immunity, not to let her answer things that they then can't use in a prosecution. So I have always felt that there was at least a chance that the state has something that they haven't used against her, that they didn't need against Charlie, that they won't need against Donna, that they didn't need against Katie or Sigfredo, but they have it and they haven't pursued it at all, at least in public, because they want to be able to use it and not be risk the inability to use it because of the immunity that she has.
Again, that's why we call her the professor. Very thorough, and you learn from her every time she talks. Tim Jansen, I don't know. Tim Jansen, he went where the money is. Criminal defense. He could have been a professor, I think. Maybe. Tim Jansen, same questions here. Will this trial be continued to when? Will Wendi be indicted? Your final thoughts.
It'll be trial will be moved to August or September. And I will tell you, for the first time today, the tenor in the air, I feel a change. In having a conversation with some people, I think there's something out there now about Wendi. It was the hush and just the climate, talking to some people involved. I think there may be something coming down.
If you've been following this, that's big news coming from Tim Jansen at 1 hour and 55 minutes into this show. We might have to cut that as a promo, COE. Tim Jansen now saying maybe the tide is turned against Wendi with an I, Adelson. We will see. By the way, Tim, the next court date is May 16th. The court is reserving the ruling on the continuance. What should we expect May 16th? And when? This is, I promise, the last question. What should we expect on the 16th? And how soon will Judge Everett rule on this continuance?
Well, the judge also said, if upon my ruling, May 16th date may go away. So I think we're going to get a ruling on the motion to continue before May 16th. And I think he will then extend the deadline for discovery.
There you go. What about the Wendi indicted question? You just answered it, right? Maybe. Tim?
I didn't. I'm just saying the conversation I had and the response was completely different than I've had before.
Yeah. I know I keep doing it. Julia, you can hang up on me, but I got to ask Tim one last question. So they said that this investigation was launched in the fall, and Julia, I'd love your take on this too. And we went back, Joe and I, before you both were on this, and back in the fall was around the time that Sarah Youssef, who was Wendi's sort of ex-friend from, I guess, law school, or an ex-lawyer friend of hers, reached out apparently to the state. I mean, Julia, I'll let you go first. Is that a possibility that this new investigation was potentially prompted by someone like a Sarah Youssef? Oh, you're muted, Julia.
So that's why I muted it. I think that's a great hypothesis that gave them what they needed, because you can't just arbitrarily say, I think there's something fishy going on with Wendi. Let me go get a search warrant and get a warrant for a wiretap. You can't do it arbitrarily. There's got to be some kind of credible information that you can use to obtain that. And getting something credible from a friend who can say, this is what I heard, this is what she told me, this is what she's hidden, this is what I was never able to reveal before, could be enough information to move forward with that. I also wonder, I don't know what the exact month was on the date of that the launched investigation. I know fall, but if it had anything to do with these questions surrounding Charlie and his counsel and the whole shakeup when we thought we were going to trial. So possibly.
Yeah. And then Tim, I would be remiss if I didn't ask you that. By the way, a lot of people have been asking about John Singer. He is a very busy attorney who I do not pay to come on, and he's busy. But he promised that when the trial gets underway, he will come back on and give his analysis. Very, very smart guy, obviously great guy. And if I go to Diddy, he and I are going to grab drinks. So Singer is out there, and hopefully he'll be back on soon. Tim, What was I just asking about? What was
Sarah.
this last? Oh, yeah. What about that, Tim? This investigation was launched in the fall. Could it be related to information gotten by Sarah Youssef?
You know, I who knows? Maybe. I take it the investigation was launched in October, and then maybe it stalled, and maybe that's why they got the wiretap in February. So they kept saying the dates on the wiretap, February 21st, but they didn't say the year. So I was curious, was it 2025 or 2024 for the wiretap? But I take it it's probably 25 in February and October in 24. So the investigation may have stalled to the point they couldn't do anymore. That's when they went to the judge in January and got the wiretap.
Wow.
And I don't know what it's about.
Yeah. Amazing analysis today. Joe was on solo for a long time. Tim got in here. Julia Jenae with Court TV. Make sure you check out Julia and our pal Vinny Politan. Brenda Macias Donna has made peace with her guilty fate. I don't know about that. And she will try to delay her trial to delay Wendy's arrest. A mother's deadly sacrifice. Who knows? But what a dramatic conclusion potentially to all this. Love how Tim figures things out. Awesome show. Case will never end. Another twist and turn. Love you, America. Love you, Court TV. Love you, Julia Jenae. I'm going to be on Josh Ritter's show tonight. Thank you, Tim Jansen. Love you, Tallahassee, Jersey, Georgia, as in Atlanta, but also Georgia Kappelman. And it's all about justice for Dan Markel. We don't hear his name enough. And thoughts go out to Ruth and Phil and Shelley, who are, once again, as I said, getting dragged through the mud. Is justice delayed? Justice denied? I guess it is for the Markels. See you guys. We're going to do another show on this tomorrow. See you then, everybody. Thank you.